The United States Department of Justice, DOJ, has launched a sweeping new initiative to prioritize the denaturalization of naturalized American citizens, raising alarm among civil rights advocates and immigrant communities. The policy shift, introduced through a June 11 memo by Attorney General Brett A. Shumate, targets individuals who obtain citizenship through fraudulent means or who have engaged in serious criminal conduct. According to internal DOJ documents, the department is focusing on cases where naturalized citizens may have lied or omitted key facts during the citizenship process. Offenses being prioritized for civil denaturalization include war crimes, terrorism, gang affiliation, sex crimes, and large-scale fraud, particularly healthcare and immigration fraud. While the DOJ asserts that the program is aimed at safeguarding national security and upholding the integrity of the naturalization process, the scope of the policy is unprecedented. With more than 25 million naturalized citizens in the United States, critics warn of a dangerous precedent that could create a two-tiered system of citizenship. The U.S. Department of Justice, under the new leadership of Assistant Attorney General Brett Shumate, issued the memorandum on June 11, 2025, outlining 5 major enforcement priorities for its civil division. Alongside aggressive actions against private sector DI programs, anti-Semitism, gender-affirming care, and sanctuary jurisdictions, DOJ has firmly placed denaturalization of U.S. citizens among its top-tier goals. First place medal the 5 priorities according to the DOJ memo, the Civil Division will focus on combating discriminatory DI policies and federally funded private entities using the False Claims Act, ending anti-Semitism among federal fund recipients, protecting women and children, including restrictions on gender-affirming medical treatments for minors, challenging sanctuary jurisdictions at the state and local level, denaturalizing naturalized citizens who obtain citizenship by fraud, misrepresentation, or later engaged in disqualifying conduct. High-profile enforcement already underway. The DOJ has already begun acting on the memo. On June 13, the department successfully stripped citizenship from Elliot Duke, a UK-born U.S. Army veteran who was convicted of distributing child sexual abuse material. Duke allegedly concealed this conviction during his naturalization process. The case was handled under Operation Prison Lookout, one of several DOJ campaigns aimed at targeting individuals deemed to pose serious threats to public safety. While most cases target severe offenses, civil rights groups note that the broad language of the policy gives U.S. attorneys wide discretion to bring cases beyond the outlined categories. This has sparked concern that minor infractions or technical errors during naturalization interviews could be used retroactively to justify denaturalization. Implications for Jamaicans abroad. Naturalized U.S. citizens of Jamaican origin or other diasporas may be affected if they misrepresented material facts or engaged in serious crimes before or after naturalization. The civil nature of proceedings means cases could advance more quickly and with fewer legal protections than traditional criminal trials. Legal challenges are anticipated, arguing that this policy undermines due process and creates a two-tiered system of citizenship.